Hello and welcome. I am Deji Badimasi. Now, there's been so much drama lately over Section 8412 of the Electoral Act. On Wednesday, a Court of Appeal set aside the judgment of the Federal High Court in Umuahia, which voided the provision of that section of the Electoral Act. Delivering the judgment in Abuja, a three-member panel of the court held that the Umuahia High Court had no jurisdiction to have entertained the case because, according to the panel, the plaintiff, Nduka Edede, who is a lawyer, lacked the local standard to have filed the suit in the first instance. However, the Court of Appeal went further to determine the case on the merit and eventually held that the provision is unconstitutional because it violates Section 42(1)(a) of the Constitution and denied a class of Nigerian citizens their right to participate in an election. So in simple terms, the Court of Appeal agreed with the ruling of the Federal High Court in Umuahia that Section 8412 of the Electoral Act is unconstitutional. Meanwhile, President Muhammadu Buhari has directed that all members of the Federal Executive Council running for elective offices must submit their letters of resignation by May 16th. President Buhari also asked ambassadors, heads of agencies, and other government appointees with political ambition to step down and hand over to the most senior officials in their organizations. Now, we do not know for sure if the president's action was precipitated by the controversial Section 8412 of the Electoral Act, because if that is the case, then the whole thing becomes confusing in the light of the appeal court ruling that Section 8412 is unconstitutional. Perhaps it's a case of the president exercising caution here. We just do not know. In any case, some political appointees in Bauchi State have now dragged INEC and their party, the APC, to court over threats to disqualify them from participating in the 2023 election on the basis of Section 8412. They have asked the court to determine if that section of the Electoral Act can be used to disqualify them on account of being political appointees. They argue that Section 8412 is discriminatory and unconstitutional, something, of course, the Court of Appeal also said in its ruling. There's no question at all that we're going to see more drama in the coming days over that controversial section of the Electoral Act, and that the Supreme Court may eventually have the final say. But joining me on the program right now to make sense of all of this is Tony Agada, who is a legal practitioner. Mr. Agada, thank you very much for joining us on the program. What do you make of all of this, all this drama? What do you make of it?
Like you said, the president is being courteous, and there is high level of uncertainty in the whole issue, because even the Court of Appeal decision also is creating more controversy. Okay, the Court of Appeal appears to say that that section is unconstitutional, which many of us do not even agree with. Oh, okay, the basis of the decision striking out the case is because the court held that the plaintiff had no local standing.
Yes.
So it's to that action. So the matter was struck out. So the controversy is still there, and that is why you can see that the Court of Appeal went ahead to profile an opinion. And if you read that judgment, they said in the event that, of course, they know that the matter will go to Supreme Court. That is why they now prefer an opinion, a decision on the merit, which in any case has no effect on the judgment that has been delivered.
Now, but let me ask you this. What exactly, as it stands today, what is the law?
Yes, the law is that Section 84 sub 12 is valid. That is the law today. And
that is not valid, right?
I think it is.
Let me get that again.
Is doing is right.
Excuse me, I didn't get you. I didn't get you.
Yes.
What did you say is the law today?
Section 84 sub 12 is the law. It's valid. It's a valid law.
Now,
that means that
what about that decision by the Court of Appeal?
The decision by Court of Appeal? No, that decision of Court of Appeal is just an opinion. You see, if you read a judgment, you have the main judgment, okay, and the main judgment is that in that matter is that the decision of the Federal High Court has been set aside. Now, the decision of the Federal High Court set aside means that there is no
from my
anymore.
understanding, from my understanding, speaking with some other lawyers, is that
Yes.
look, yes, it set it aside. The Court of Appeal set it aside, but then it then took on the case on its merit, and that going by, excuse me, that going by the current. Going by the current, is it practice direction now, that the Court of Appeal can actually do that. And so that's the reason why it did what it did.
Yes, the Court of Appeal did that because why they did that, the practice is this. Okay, the directive to all judges, even when you are deciding that you have no jurisdiction, determine the matter also on the merit.
On the merit. So okay. if the matter was determined on the merit, then can't we... If the matter, excuse me,
it's an opinion. It has no effect.
Wait, what I'm saying, you are saying it's a legal opinion, it has no effect at all?
It has no, it has no effect.
Oh, really?
It is not the law. The law today is that the decision setting aside section 8, nullify section 84, sub 12, has been nullified by Court of Appeal. And that is it. If you read the judgment, the court said, after nullifying setting aside the judgment, they now went ahead to say, however, okay, assuming there was jurisdiction.
No, because I didn't see any assumption there. I mean, the language is that determining the case on the merit. It's something I really want to understand.
On the merit, yes, determining the case on the merit. Now,
that is no assumption.
Now, what I'm telling you is this: a case that you have no jurisdiction on, can you determine it on merit? Can you give a decision in a matter that?
But that is what. That's why I have just told you that we understand that the current practice direction is that the Court of Appeal can do that.
You can do that. You are doing that. So why the courts or the courts are enjoined to do that is that so that if the matter go on appeal and the decision of the lower court, the Court of Appeal is set aside, the Court of Appeal, the Supreme Court will no longer remit the matter back. So the Supreme Court will already have a judgment to rely on. That is the basis for that. So that you don't, when
you are saying the Supreme Court already has a judgment to rely on, if this is the judgment you're talking about, the judgment of the Court of Appeal, then it's a judgment. That should be the valid law. So which means if you're referring to these as the judgment of the Court of Appeal, it means as it stands today, Section 8412 is not a valid law.
So I don't agree with you.
No, I'm just saying. I'm asking you. You are the expert here.
It is not at all. It is not at all. Read the judgment. I have read the judgment. Read it. The judgment says the Federal High Court has no jurisdiction. And the matter was not only, the decision was not only set aside, the suit was struck out. If the suit was struck out, then there was no suit in the first place, and there was no appeal at all for you to rely on. So even the Court of Appeal decision is not, if you cannot even rely on the judgment that you are calling judgment of merit, because it has no foundation for you to rely on the basis has been nullified.
I guess we'll have to get another legal opinion on this.
Yes. I think so. But I think that is the law. That is the law. That is my opinion on that.
But you see this going up to the Supreme Court?
Yes, I see that. I see it going to the Supreme Court. And I expect the PDP to also go to the Supreme Court against that portion of that ruling where they affirm the nullity of Section 84.
Why would that be? If as you have said, it's not a judgment, so why would you be appealing against that?
You said?
I mean, if you say it's just an opinion, why then would the PDP be appealing against that?
Yes, you see, it's like a finding. It's a ruling. It's a finding. You can appeal on a finding of a court. Are you getting me? It's a decision of a court. You can appeal on it. So they can go and appeal. Why and urge the Court of the Supreme Court to affirm the judgment of the Court of Appeal on two grounds. One, firstly, that the lower court has no jurisdiction. Secondly, that Section 84 sub 12 is not unconstitutional.
All right.
So all the Supreme Court will now do is to affirm that section.
The whole thing is, to be candid, the whole thing is just confusing, and I can understand why the president has decided to exercise caution.
Exactly.
But it's also interesting. It's also interesting that some party members in Bauchi State have decided to go to court as well to challenge this section. We just have to wait and see what comes out of that.
Exactly.
Yes,
exactly.
And the hope is that this will be given an expeditious hearing, because the party primaries are coming up very, very soon.
Yeah.
Well, Mr. Tony Agada, thank you very much for joining us on the program, and thank you for your time.
Thank you very much. I am pleased to be here. Thank you.
Thank you so very much. All right.
Thank you.
We'll take a short break now, and when we come back, we'll get a second opinion on this. Stay with us, don't go away. Welcome back. Let's continue the discussion. I'm now being joined on the program by another lawyer, Evans Ufeli. Evans joins us from another part of Lagos via Skype. Thank you very much, Evans, for joining us on the program. Let me get your take on the decision of the appeal court on that controversial section 8412 on Wednesday.
Yes, what the appeal court did was to discharge its function, its constitutional function. The matter was first decided by the Federal High Court in Umuahia, where your Lordship delivered a judgment voiding Section 8412 of the Electoral Act 2022. Now, the matter went on appeal to the Court of Appeal, and then the Court of Appeal came up with a judgment yesterday that the lawyer who filed the case has no local standard, that he does not have a cause of action, and it couldn't have been of the right legal capacity to have filed that suit. Okay? Therefore, the court now made its own pronouncement that though the said Section 8412 runs contrary to Section 42, subsection 1 of the 1999 Constitution. Okay? So it established that. Meanwhile, it's in a way, okay, made a pronouncement on the merits of the issue in question. That is taking down the litigant, the respondent now, that is the lawyer who filed the case in the court of first instance. Taking him out, that he does not have a legal capacity. But however, on the merit of the issue in question, the section of the Electoral Act under reference, okay, is at variance with Section 42, subsection 1 of the 1999 Constitution as amended, which talks about the issue of discrimination of citizens. That certain persons, certain class of persons by virtue of their appointment in office are discriminated against based on the provision of that law.
Now, let me ask you this. So on the basis of that pronouncement of the Court of Appeal, can we say, as we speak today, the law is that Section 8412 of the Electoral Act is voided?
Yes. Section 8412 of the Electoral Act is voided not because of the merit, of its composition, but because the lawyer in question who filed it, okay, does not have capacity. That is, the court of first instance. The court of first instance did not look at the capacity of the lawyer who filed it. Okay, it didn't. Okay, but the court of appeal looked at the capacity of the lawyer who filed it, but however, still agreed with the court of first instance technically.
Yes.
Exactly. Yes, it agreed with it, okay, on the merit, but took down the litigant. So that the reason the Court of Appeal did that was to cover the field. So it will not look as though everything is appropriately done according to law. Someone lacks legal capacity. But despite that, the provision so touted about also runs contrary to the provisions of the 1999 Constitution. By implication, therefore, it means that the Court of Appeal actually agreed with the Court of First Instance.
Oh, that's fantastic. So it means if anybody has any issue with that now, the next stage would be to go to the Supreme Court. Because as it stands today, it means people can actually not be disqualified on the basis of Section 8412. They can be disqualified from taking part in the electoral process in their political parties.
Yes, they cannot be disqualified. But they must obey the part of the section of the Constitution that say they must resign 30 days.
30 days, yes, absolutely, no doubt. Now,
that's the
okay. Now help us to understand this, because part of the issue at the very, when the court gave this, the appeal court gave the judgment initially, some people had argued that, look, the moment the Supreme Court, the moment the Court of Appeal said the lower court, the Court of First Instance now didn't have jurisdiction, that it should have ended there, that it should not have gone ahead to even look at the matter on the merit, that it probably overreached itself. I want you to react to that.
No, it didn't overreach itself. The court can suo motu. That's what they call suo motu. The authority of the court is not just to look at the issue in question. Okay? That's what they call consequential orders. If you look at the case of Amechi or Celestino Meya at the beginning of return to democracy, the parties who went to court was not even the party that was finally brought as the governor of Rivers State. Okay, the court made a consequential order. The court said that this is the person who won primaries, talking about Amechi, and then was substituted. That in this case, the court made a ruling and then made a consequential order that even though he did not contest the election, he has to. So the court can make consequential order. Okay, and that's exactly what the court did here. It is not that the court must restrict itself to the matter before it. The court have the authority to make pronouncements and then make other issues that are connected to the issue in question in court, make pronouncement to those effects. The court did not overreach itself in any way. It is the duty of the court to interpret the law. Okay, that is the primary function of the court. And the court can choose to interpret the law and spread it however it deems it fit for the benefit of society. And that's exactly what the Court of Appeal did. There is no overreaching whatsoever. And even if there is any, it does not lie in the mouth of anybody to say that. It is the Supreme Court that will decide whether or not the Court of Appeal did the right thing. But in law, the court can suo motu make a pronouncement on issues that are not even the issue before it, but are issues that are connected thereto.
How do you, do you think this case is going to go to the Supreme Court?
Definitely, because it is a sensitive one. It's a sensitive one, and especially when the president had also come out to, ask these persons to resign.
Do you think the president's action was based on that section 8412?
Earlier on, the day the president signed the Electoral Act into law, he called on the National Assembly. Okay, after he had signed it and drew their attention to it, that they should amend it. Okay, but the National Assembly hadn't done that up until now. I think the problem started from when the president had vetoed that bill 5 times. And as at the time he signed it into law, there were already, civil society, people were already on the streets 2 days to the day it was signed into law that if the president vetoed it again, there's going to be an outburst of protests and the rest of it. So perhaps that made the president and then the international community watch it. That made the president to, just sign and then drew their attention
So
to it.
do you think the president's, order that his ministers should resign, those with political ambitions, you think this was the president exercising some kind of caution over Section 8412? Because, I mean, since the Court of Appeal had made a pronouncement on it, you would have expected that, look, ministers can still stay in office until 30 days before the election, unless, of course, the Supreme Court, if the case goes to the Supreme Court rules otherwise.
Yes, but the president made that statement before the judgment.
Yes.
The president's statement came earlier, and then the judgment came later in the same day. You understand? The implication of this is that if any minister who is willing to contest election and by the president pronouncement refuses to resign, that statement is persuasive. It is not law. It is not law as it stands right now. If a minister decides not to, what will happen is that the president only have the right to sack. The president does not have the right to force a minister to resign. Having made that statement, the affected persons have a right under the law to go and seek for an injunction. Okay, it's open to them to seek legal redress if they are not willing to resign. Someone like Chris Ngige isn't willing because he has argued back and forth before now that he's not going to resign. And some other persons who are in that bracket. So if they choose not to resign, they have to go back to the courts. Okay, because those positions, somebody said that they are employee of the president, and I disagree because those positions are statutory provisions.
Exactly.
Of they are employees of the presidency and not the president. The president have a mandate. These persons, okay, occupy those offices because they are offices that are constitutionally provided for. The office of the Attorney General, for example, is created by Section 150 of the Constitution. His functions is created under Section 174 of the Constitution. And that applies to all other ministers. Even the president himself, his office is created by Section 130 of the Constitution. Those offices are created by the Constitutional Referral Government of Nigeria. And there are procedures of law upon which a person who occupies the office can be removed from that office. And those procedures does not include forcing them to resign or asking them to resign outrightly, whether persuasive or by coercion. Okay? But the president have the power to sack any of the ministers. But as to asking them to resign because they want to contest election, it's not what the provision of the law is. So the affected minister will have to seek legal redress. Those who are not willing to resign, we need to seek legal redress and let the court make a pronouncement. But all this is coming at a time when we do not have much time in our hands.
Yes.
The political parties are already asking INEC to shift the time, and then INEC is saying no because the timetable came out since February, and all political parties ought to have done what they ought to do before now. So there's going to be, in the next 6-7 months, there's going to be a lot of political and legal stunts in our political firmament.
Absolutely.
And
I have no doubt about that.
We must be ready to absorb both the judicial system and the political system, must be ready to absorb all the controversies that are going to come out from this.
There's no question at all. It's going to be a very busy time for people like you. I mean, this is the time that your profession has been waiting for.
It's for the purpose of expanding the judicial system and our legal system.
Yes.
It's even good that some of these things are happening so that it covers the field for the future. We can now have precedents. When we create these precedents now, in future, that is how democracy develops.
You're quite right. Ivan Sufeli, thank you very much for joining us on the program, and thank you for your insights there.
Thank you.
Thank you so very much. Well, that's how much we can take on the program this week. Thank you very much for watching. I'll see you again next week. Bye-bye.